Dear colleagues, it's a pleasure to join the conference and to share this presentation. Unfortunately, I'm not able to come to Budapest and see you in person because of personal reasons this November. Once again, I'd like to thank and to congratulate Ferenc Madl Institute and wish next successes and all the best in the future researches. This time I'd like, in cooperation with Professor Monika Niedźwiedź, present some our earlier considerations and thoughts on the topic Economic freedoms versus protection of child's rights and parental duties. Some remarks on the issue of access to internet pornography.
Ladies and gentlemen, I would like to thank you for the possibility to join the conference, and I would like to move on to the main topic of our presentation. During the last decade, internet has become the commonly available medium in the world, and the recent pandemic situation increased even the process. We all have computers with us, smartphones, and even household devices connect with the internet. Children are among the recipients of internet and at the same time they are sensitive persons, sensitive users of the internet. Internet has also become a widely available medium for economic operators. It creates new opportunities for economic development, also for faster, easier access to market and reaching new clients, including children. This creates new opportunities for market development. A new category of clients appears. But at the same time, due to the age and sensitivity of the youngest, it results in the need to take responsible action for safe use of the internet and to take steps in order to protect the youngest against harmful content in the internet. It's worth mentioning that contact with pornography is not only the result of action consciously undertaken by a child, a teenager, but also it is usually a result of searching for other content, so-called neutral content. There are several ways undertaken by pornography business to mislead young user who does not look for pornographic content at all. In fact, nowadays children potentially have adult content in their pockets all the time. That's why we decided to consider whether it's worth taking social and legal action in order to protect children against harmful content in the internet, such as violence and pornography. There are sociological, psychological, and health research that show that early consumption of pornography is very detrimental to children, as it inappropriately shapes their attitudes to sexual life and behavior, usually includes violence, significantly disturbs the development of their personality, distorts the physical relationship between a woman and a man, increases aggressive behaviors, and may have long-distance detrimental consequences for relationships and the foundation of the family. On the other hand, we should pay attention to parental authority and responsibility of mother and father, which means inter alia the rights and obligations, including the obligation to protect and maintain the child. Children use internet not only under watchful eye of their parents. And the question arises, are parents able to exercise the duties on their own? In fact, parents need support to exercise these obligations. Now we would like to move on to the question of legal grounds of possible action aiming at protection of children against pornography in the internet. I would like to consider constitutional grounds provided for in the Polish Constitution of 1997. We have, for example, Articles 48 and 53, according to which parents shall have the right to ensure their children a moral and religious upbringing and teaching in accordance with their convictions. We have also Article 72, according to which Republic of Poland shall ensure protection of the rights of the child. And here we have so-called Actio Popularis. According to the article, everyone shall have the right to demand of organs of public authority that they defend children against violence, cruelty, exploitation, and actions which undermine their moral sense. Of course, it is up to the legislator to specify and give a legal shape to these obligations.
Now I'd like to consider some legal grounds of international origin. Please have a look at United Nations Convention on the Rights of the Child. I think we should focus on Article 19. According to this article, contracting states are obliged to take all appropriate steps in the legislative, administrative, social, and educational fields to protect the child against all forms of physical or psychological violence, including the harmful effects of internet pornography, in our opinion. Article 13 says that child is to have the right to freely search, receive and transmit information and ideas, but the exercise of this right may be subject to restrictions, to legal restrictions, if they are necessary to respect the rights, reputation, and for the protection of their health or, in general, social morality. Article 14, paragraph 2 says that contracting states, nearly 200 of them, are to respect the rights and obligations of parents. The rights and obligations of parents, including parental responsibility that was signalized before. Rights and obligations of parents to direct the child to exercise his or her right in a manner consistent with the child's developing abilities. And Articles 16 and 17 of this United Nations Convention should be also mentioned. According to Article 16, child is not to be subjected to arbitrary or unlawful interference in the sphere of his private life or attacks on his honor and reputation, and has the right to legal protection against such attacks. Article 17, one of the most important in our opinion, states recognize the important role of mass media. States are encouraged to develop appropriate measures to protect children from information and materials harmful from the point of view of their well-being. And this obligation is without doubts applicable to the content currently distributed in internet resources by internet providers. Also, conventions prepared under auspices of Council of Europe could be mentioned, two of them. They are not so general. They are focused on cybercrimes and pornography with children. First of them, the Council of Europe Convention on Cybercrime of 2001 says in Article 9 that each party shall take legal and other actual political measures that may be necessary to establish as criminal offences under its law the child pornography in general, also distributed by means of IT systems, including this form of internet. And the second one is Council of Europe Convention of 2007 on the protection of children. And it can be read in this preamble that in particular, as regards the increased use by both children information and communication technologies, and that preventing and combating such sexual exploitation and abuse of children require international cooperation. And under Article 22 of this convention, parties of this international treaty prepared under auspices of Council of Europe should undertake and should ensure the punishment. So the method of criminal public law. Let's go to the European Union instruments.
European Union, as early as in the 1990s, has recognized the need to protect the youngest from the threats coming from the internet. So the issue is currently included in EU policy making. In 1999, the Safer Internet program was launched, aiming at safe use of new technologies and the internet among children and young people. However, focus has been mainly on the protection of children against child pornography, and some legal acts has been adopted, namely Directive on combating the sexual abuse and sexual exploitation of children and child pornography. It's also worth mentioning Article 24 of the EU Charter of Fundamental Rights, which gives a solid grounds to take action against pornography. Children have the right to protection and care which is necessary for their well-being, and in accordance with this article, actions concerning children, whether taken by private or public authorities or private institutions, should be subordinated to the best interest of the child. In the year 2011, the European Commission prepared a report, Protection of Children in the Digital World. However, the European Commission did not decide to take legislative measures. Instead it granted a priority to self-regulation method because it is a much more flexible, according to the European Commission, instrument to achieve visible results. An initiative, as a result of this report, an initiative based on self-regulation was launched, the so-called European Framework for Safer Use of Mobile Phones by Children and Young People. And on the basis of this document, codes of conduct are also adopted also by by Polish operators. The codes, however, do not guarantee effective protection of children against inappropriate content. Although they identify content inappropriate for children, they educate parents. They provide parents and guardians with information about using and safe use of internet. However, they do not give the possibility to block access to harmful content. And here we come to the main issue of our presentation. We have the main issue, meaning the balancing of values. We have on the one hand the right of children to safe internet, the rights of children, the rights of parents, and on the other hand we have economic freedoms, freedom to provide services, freedom of establishment, as well as freedom of expression or the right to privacy. And the question arises how to balance these values which deserve the protection. Well, from, for example, the European Union law perspective, we know that economic freedoms are not of absolute character, and if we look at the provisions of the Treaty on the Functioning of the European Union, we can find their provisions, the so-called derogation clauses, which allow for restriction of internal market freedoms. Before we will discuss the ways of balancing of values, the methods of balancing the legal solutions, I would like to give you two examples of legal attempt to restrict access to pornography. The first example comes from Poland. In the year 2013, Polish parliamentary resolution was enacted calling for the Minister of Administration and Digitalization to guarantee parents the right to internet without pornography. The resolution contained guidelines which the proposed regulation should take into account. Namely, every person should have the right to request an internet service provider to block the transmission of pornographic content. Secondly, the internet service provider should be responsible for developing effective filters that would block the transmission of pornographic content. And thirdly, the internet service provider is required to provide internet access without free pornography. However, the idea was abandoned because there were doubts as to the compatibility with the EU law, especially with internal market economic freedoms. Another example comes from the United Kingdom. It's an example of combining a politician's determination, self-regulation and normative regulation. The main point of the British system was the activity of an organization called Internal Watch Foundation, founded by the British police and prosecutors, as well as leading market operators providing internet services. The latter, after political pressure, have committed themselves to comply with the standards developed by Internet Watch Foundation, and the result of this cooperation was the system called Clean Feed Content Blocking System, founded in the year 2004. It was a kind of a filter blocking the content which may be harmful for children. The main assumption in the system was to disable access to pornographic content, and the lock can be removed at the express request of the consumer. The campaign was complemented in the year 2017 by Digital Economy Act, which aims at ensuring that economic operators making profits from the internet Pornography have a legal obligation to verify the age of the consumers. However, the effectiveness of this regulation has been criticized, and the main concerns have been expressed with regard to verification requirements, and it was pointed out that it may lead to the creation of databases of British porn practices and collections of identity documents open to abuse. In our opinion, the fears are not convincing, because we should take into account also the other side of the coin, privacy of children and parents. What about the children being de facto chased in the net by e-porno business? What is more, we all know that contemporary legal systems at national and international level provide at national and supranational grounds legal solutions with regard to the protection of personal data, taking GDPR regulation at EU level as an example. It is possible to restrict economic freedoms, legally restrict economic freedoms or freedom of expression or the right to privacy. And I would say that there are European or even international standards how it is legitimately allowed to restrict these freedoms. The conditions are that the restrictions are provided for by law. They protect legitimate objectives such as public policy, public security, public morality, and they are necessary and proportional. And in terms of proportionality, some issues may arise. In the context of the principle of proportionality, we come across the problem whether to block or whether to limit access to pornography. So whether we should take into account a total ban or a kind of selective regulatory measures. For example, in the form of a blockade that can be turned off at the consumer's request, as it is in British system, or blockade of domains entered in a special register. In our opinion, it would not amount to a total ban, as today IT and artificial intelligence development allow for the precise measures which may be a solid basis for these selective measures based on regulatory access.
Summarizing, we are of the opinion that it's better to do anything than to do nothing. The current situation in many states in the whole world of non-activity, of a kind of failure to act, means not only status quo, it means it results in the progressive infection of next generation of our children. In order for the normative intervention to be successful, the observance of the principle of proportionality is of importance, as it was said. And this method, this idea of balancing values, shaping freedom of internal market, freedom of expression, but also the right to privacy, not only from the perspective of consumers, but also from the perspective of children and their parents. As far as European Union law is concerned, in our opinion, it includes more catalysts than obstacles for effective protection of children. From international and European law perspective, it follows that we are not faced with a kind of dilemma whether to do something, but how to do it effectively. How to do it effectively? This is the question. So, summarizing, in our opinion, measures for the effective protection of children shall be comprehensive. They shall combine parental supervision, self-regulation, and legal provisions, both of preventive and repressive character. As far as technical measures, technical issues are concerned, technical solution could be based on the best available technique principles and also based on the developing internationally also developing artificial intelligence, and it would pass the test of proportionality. Finally, this is an important, in our opinion, task for the states, for including our countries, but this should be also an important task, taking into account the current era of internet, of common access, of a kind of cheap access, wide access. It should be an important task also for international organizations, for example, United Nations, Council of Europe, and European Union. And I'd like also to recommend a publication, a book published recently by Publishing House of Instytut Wymiaru Sprawiedliwości in Warsaw. Please have a look at this book and have a look also at the content. I would like to recommend in this book titled Marriage, Children and Family, Modern Challenges in Comparative Law Perspective, edited by Grzegorz Blicharz. I would recommend interesting and comprehensive texts written by the authors coming from different countries. Thank you very much for attention. See you. Goodbye.